So what I'm going to talk to you about today is going to be firstly, it's two parts. So first I'm going to talk about the January 2023 amendments to NEC4, and then we're going to go on to some recent cases in the last year. Don't worry, I'm not going to go talk to you about climate change in X29, because I think that Richard and Barry have more than covered that for us. So that one you won't have to have repeated. So NEC4 amendments. I mean, NEC4, actually just on that point of X29, I haven't ever talked about it at all. You know, that's a good example of NEC really adapting and being quite, sometimes even pioneering in actually taking on new issues that are affecting modern practices. And I think this first one that I've got up here is another example of that. So one of the amendments I want to talk to you about firstly is the schedule of cost components and the update to that. And, you know, whilst we might be living in a post-pandemic world, there are many things that still remain from COVID, unfortunately, or fortunately, actually. And whilst more and more people seem to be coming back into offices and workplaces, the reality is hybrid working and flexibility on working from home seems to be here to stay. So this has now been reflected in the schedule of cost components. So it gives the option, you can see in the red, that new limb there, that it gives the option to list people in the contract data whose costs can be recovered as part of the defined costs, even if they are not normally based in the working areas. So this is subject to the proviso that they're not working on manufacture or fabrication or design. Interestingly, the project manager can also agree to treat additional people as if they had been listed in the contract data, which again, that's a very good, great way to retain flexibility going forwards on the project, because we all know that the people and the circumstances on a project can change. So the cost of people working from home or otherwise outside of the working areas on a more permanent basis will be recoverable if agreed at the outset of the contract, or even if they're agreed during the project. And it's important to note the cost for all people working from home will not necessarily be recoverable by default. It's only the defined costs of those people who are listed in the contract data, whose normal place of working is not within the working areas or the service areas, whichever contract you're using. So this amendment really is bringing in the recovery of people costs in line with working or current working practices. Clients should consider whether they wish to, or clients and contractors should really consider, you know, what they're thinking of in terms of any supplementary notes to this, just to ensure the sort of swift operation of it, particularly in terms of things like, you know, how they're going to agree any additional people that are going to be treated as if they were originally in there, what kind of parameters you're going to include around that. That might be something to think about, but it's definitely a good move, a step in the right direction to sort of reflect current working practices. So the next amendment, X22. Now, those of you that were here last year may remember that, again, last year I was talking to you about updates to X22. So it's good to see that it's evolving. You know, as we said, maybe next year we'll be talking about amendments to X29. But yeah, I think that these amendments are actually reflecting the increased use of X22 and early contractor involvement. And again, obviously these amendments come from industry feedback and NEC users, and so they're intended to really try and reflect a better reality. And these particular amendments are generally around the process between stage 1, the pre-construction phase, where everything's being consolidated, and stage 2, the construction phase. And also, I was just going to say this just to avoid John, also to enhance collaboration within stage 1 between the contractor and project manager. So what are the changes? We have the site information that can be changed by agreement during stage 1, which is quite an interesting one. Otherwise, this might have to be changed on the project or on a contract by some sort of supplemental agreement or side agreement. And it's recognising that that kind of information might not be set in stone. That's why you're using X22. You might not know. So it's a very annoying fly here. you might not know anything at that stage. There might be some changes that actually that engagement with the contractor brings about. So that's quite an interesting one to have there right at the outset. If the parties terminate during stage one, it's now been clarified how that works in terms of the termination costs, and the contractor, if it was a client default, would be entitled to the excess of the first forecast defined cost for stage one over the price for work done to date, less the fee. So this would mean that the contractor is paid essentially for the loss of expectation of not continuing stage one, but not including overhead and profit. Another change is the clarification of the process where the project will not be proceeding to stage two. Now, I think in the last set of amendments, we were clarifying the process where there was a notice to proceed. Here, what we're doing is actually asking for there to be a notice not to proceed, just so that it's all joined up and clarified. And as part of that notice not to proceed, there's an instruction from the project manager to de-scope in stage two, and that's also going to include, or that should also include, the relevant changes to the completion date in line with the date of completion of stage one, and to change the prices to the price of work done to date at that point, meaning that everything is kept whole there, and that there is no sort of incentive payment as well that will become due. If in the alternative situation we have a notice to proceed, there's been more clarity on that as well. That should actually say that CEs that occurred that are judged after stage one. But the really important thing about that first bullet point is that the compensation events will be, going forward, once you've got your notice to proceed, compensation events will be judged against the date of the notice to proceed, and not against the original contract date, so that's stage one, or that stage one contract date. And that obviously is there to try and reflect all of the benefits of that stage one process, and you've got your updated dates and everything in the notice to proceed. So you've got your changes to the prices and the completion date and the key dates, and that's providing the sort of clear baseline and really providing that benefit of having had that whole stage one process. Again, another change is in respect of the termination costs again. So that's really just to make it clear that after the notice to proceed, then we're taking into account the changed prices and that first forecast and defined cost that is in that notice to proceed. So again, you're not applying the stage one prices or dates. So moving away now from X22 to clause 22, core clause 22. And here you can see in red the change, and here it's really extending that sort of copyright license wording. So to say that the client can also use and copy the documents that are prepared for the design. And this is another good example of moving sort of with the market and with the times, and it's reflecting the sort of language that we do as lawyers in particular use around the copyright provisions or the intellectual property license. I would say that it probably still doesn't quite go far enough in terms of what we usually see in contracts. It is one of the things that is very, very commonly included as a Z clause to get that full intellectual property license, which is ensuring that the license is the usual wording, the non-exclusive, irrevocable right to grant sub-licenses. So I'm not sure if that amendment is really going to go far enough to stop those Z clauses coming in, but obviously you never know, it might provide some comfort. And so then we have the option clause W2.3. So this is the one that applies where the Housing Grants Construction and Regeneration Act applies. And the reason again for these is just to bring the wording more in line with the Act. So the first one there, we've got the right to provide further information, further submissions within 14 days has been removed, and I think that's generally going to be very welcomed. It wasn't needed under the Act, and it's something that was quite regularly removed or adjusted by agreement between the parties. Again, the adjudicator deciding the procedure and timetable for the adjudication, again, reflecting often reality and actually, as I say, in line with the Act. That last bullet point about the adjudicator reviewing and revising the actions and inactions of the project manager or altering a matter treated as accepted. It was there already. It actually just got moved around a bit, and I actually think it's a good put at the bottom of that clause, and I do think that actually really quite emphasises that. I think sometimes it maybe got a bit lost, and I think it's really good to emphasise that, and hopefully it may prevent some of those jurisdictional challenges that we all see. So now moving on to just the short forms, really. The short forms, so when I'm talking about the short forms, I'm talking about the engineering construction short contract and the engineering and construction short subcontract. These are generally, there's a couple of amendments that have been made to those that are generally bringing them into line with the main forms, so the engineering construction contract and the engineering and construction subcontract. And these all apply to lots of the different forms, so, but I'm just using these as some of the main examples here. It would take us quite a long time, and I think I definitely would send you to sleep to give you all of the amendments that are listed out in that table. So the first one is in relation to design and design liability. And so now they're giving the option in either the contract data or subcontract data as applicable to reduce the liability for design to reasonable skill and care. Now, the default position under these clauses, without this option being selected, impose a kind of a fitness for purpose obligation in relation to the design carried out by the contractor, which is a strict absolute legal obligation which, unlike the requirement to exercise reasonable skill and care, doesn't necessarily require the contractor to have acted negligently to be in breach. These fitness for purpose obligations are usually quite regularly uninsurable, and for that reason the obligations are regularly not negotiated out. Nobody really wants to be working with a void professional indemnity insurance policy. It's no use to either party. So both the engineering and construction contract and the engineering and construction subcontract have the option X15, which provides the standard of care is the skill and care normally used by professionals designing works similar to the work. So this amendment really is just bringing those in line with that, which really, streamlining those contracts so that can be passed down to the subcontractors, or even just having it in the short contract. It makes sense, bearing in mind that they will have the same issues with insurers in particular, and so I think that one will generally be very welcomed. Again, it's a kind of clause that's often amended. You do see that amended anyway, but perhaps even on the short contracts, it may actually just provide a better position for the contractors there, and a more realistic one for the clients. And finally, there's also now a cap on liability included in the contract data or subcontract data for the short forms, which is similar to X18 in the engineering and construction contract. Again, another example of alignment. I don't think it has quite the same level of carve-outs and excluded matters, but again, it's good to have it a step in the right direction of those contracts being aligned. So that's the end of the NEC4 amendments, and now we'll move on to the case law update. So in the past year, we'll take a look at sort of various issues that have been coming up in the past year. Now, some of these are actually really building on, again, I'm not going to test you on what I said last year for those of you that were here, or maybe I should have done that, that would have been quite me. But some of these are themes that I was talking about last year, and they've been built on again in the past year. So it's good to see that those themes are still being talked about in the courts. And also, it's good to have more clarity on some of those issues. So just to run through, we'll look at payment and pay less notices and issues around having clarity in those. Notice of dissatisfaction, that was something that I did speak about last year, and there were a couple of cases last year which I will briefly remind you of later. The dispute resolution procedures, how much do the courts really give value to them? and we'll have a look at that later, and then if we've got time, we'll just have a quick look at whether or not, the old question of whether or not collateral warranties are construction contracts. So in this first case, in Advance, JV and NEC, Advance were engaged to build a water treatment facility, and they engaged NEC under an NEC3, I think it's an engineering and construction subcontract. And it provided payment terms that you'll all be probably or hopefully very familiar with. So NEC could make an application for payment on or before the assessment date. Advance was required to assess the amount due for payment and certify a payment by issuing a contractor with a payment certificate within 3 weeks of the assessment date. Final date for payment was 21 days. Pay less notice was due 7 days before the final date for payment. That's fairly standard, shouldn't be no issues there. So the application prior to the one in question, which was application number 23, showed a difference between parties of, I think it was around 1.4 million. On the 22nd of October, NEC submitted application number 24 by email. They included an increase of another 1.4 million, or almost 40% of the project. The last date for providing a pay less notice was the 26th of November. No payment certificate came from Advance. There was no document that was provided that was expressly sought to respond to application number 24 at all. 19th of November, which ties in with the next assessment date under the contract, NEC submitted application 25, an increase of was around 85,000. But the net payment that was included in that application referred to sort of 2.7 million. So that was including the 1.4 million that was in that previous application number 24. On the 25th of November, now that last payment came in the 19th of November, the 25th of November, which was 1 day before the expiry of the time window for the pay less notice under application 24, Advance sent a payment certificate which expressly said it was for the assessment date of the 19th of November, i.e. the assessment date for application 25. The assessment resulted in a zero payment. The pay less notice made reference to application number 25 as well. And the sum considered to be due was supposed to be calculated by reference to the information that was included in application 25. Now, despite this, Advance said that the pay less notice could be relied upon as a valid notice in relation to application 24. They hadn't said it at the time, but then they seem to change their minds. They said the contractual requirements for the timing and content were met. It was sent before the 26th of November, which was when that deadline for the pay less notice expired. And the terms of the pay less notice would have indicated, this is what they were stating, it would have indicated to the reasonable recipient that Advance did not intend to make any further payment, either in respect of application 24 or 25. And NEC made the point under the Construction Act that provision was made for notices to be given in separate payment cycles, with payment notice, pay less notices according to each cycle. And therefore, those notices should refer to the notice that identifies the notified sum. And whilst there's an absolute requirement, there's no absolute requirement for a pay less notice to make express reference to the notice to which it's responding, it must nevertheless be clear that it is, in fact, responding to that notice. So, what did the court say? In the Technology and Construction Board, the judge commented that the construction notice must be approached objectively. How would a reasonable recipient have understood them taking into account the relevant context? And the judge did actually also refer to Coulson on construction adjudication, which I'll just read out to you. The courts will take a common sense, practical view of the contents of a pay less notice and will not adopt an unnecessarily restrictive interpretation of such notice. It is thought that, provided that the notice makes tolerably clear what is being held and why, the court will not strive to intervene or endeavour to find reasons that would render such a notice invalid or ineffective. So the court found that the payment notice must refer to individual payment cycles, and here, application 25 was an application for a different amount from that previously applied for in the application 24, albeit by a significant margin. Not by significant margin, but these applications were intended to be substantively different and assessed for different dates. It was difficult to see how one notice that referred to only one assessment date could possibly be said to respond to two. The pay less notice in application 25 was not a pay less notice in respect of application 24. The timing point, namely that the provision of the pay less notice one day before the end of the deadline for application 24, was, the court said, no more than neutral in the circumstances where the pay less notice was also within the overlapping period for service of the pay less notice statement under application 25. So in short, if the pay less notice was intended to remedy the failure to serve a payment certificate for application 24, it didn't make that clear. In the absence of any suggestion that it was designed to plug that gap, the reasonable recipient would have taken it at face value. The adjudicator's decision was that there was no valid pay less notice against application 24, and therefore Advance had quite a hefty sum of around 2.7 million to pay to NEC. So this case really is a warning to the clients out there to ensure that payment notices and pay less notices are clear in responding to the relevant application, particularly where the payment cycles overlap. And I think the court even did actually acknowledge in that case that was their decision, despite the significant impact it was going to have on the parties because of the delay. So now on to the cases on notices of dissatisfaction in relation to adjudication. So the NEC doesn't set out the formal content expressly. Maybe that will come in next year's amendments, who knows. It's useful to have this guidance from the courts in the meantime though. So for those of you that did attend last year, I did speak about a couple of cases on the same topic, so just here now for a brief reminder of those. One of them was Transport for Greater Manchester and Kia, which set out some guidance on the formal content of such notices. It stated that no specific form of words or level of detail is prescribed in the relevant clauses, and a notice needed to state that the decision was being disputed, but did not need to detail or explain or set out the grounds on which it was disputed. There was also another case, Prater and John Sisk, which found that a notice of dissatisfaction was required both for challenges to validity or enforceability of an adjudicator's decision, as well as challenges to the substantive merits of the decision. So in this more recent case, Metropolitan Borough of Sefton and Allenbuild carried out works to build a leisure and water park. It was an NEC contract. The council claimed for defects by adjudication. That should actually say 4 years, don't worry, there's not been a limitation issue that they've missed. The council obtained an adjudicator's decision awarding it 2.2 million plus interest and commenced court proceedings to enforce the decision. Allenbuild resisted enforcement and relied on a notice of dissatisfaction issued in relation to, and this is a quote from them, the entirety of the adjudicator's decision, including all of the adjudicator's conclusions, reasonings and decisions. It's fairly clear, I think, there. It's just everything. Allenbuild claimed that this prevented the decision from being final and binding and leaves open any challenges of any basis whatsoever, whether as to enforceability or final determination. The court wasn't really happy with that argument, and they noted that whilst the notice of dissatisfaction need not descend into the details of the substantive challenge, the issue of the validity of an adjudicator's decision is of a fundamentally different character from its merits. So the court found that in order for the notice of dissatisfaction to be valid, it ought to make it clear whether a challenge is being made to the validity, on jurisdictional grounds, or to the merits. The wording here was not sufficient, as it did not make it clear. It just said it's every part of that decision. And so in addition to the specific grounds as to the challenge to jurisdiction or validity did not actually need to be stated, but it did need to say which of those did apply. And now another case, another more recent case, I think it's Ravenstein. I'm sorry if I'm butchering the pronunciation. Maybe I'll change that up just to try and keep you awake. So in the very recent case of Ravenstein and Trans Engineering, Ravenstein are a Dutch shipyard and construction company. they entered into an NEC4 engineering and construction subcontract. Option W2 applied, and the provisions of which, as we know, state that an adjudicated decision would be final and binding unless a notice of dissatisfaction was provided by one of the parties within 4 weeks of the decision. So in 2021, Tran commenced their adjudication and claimed damages for some defective works. They were successful, and Rubberstein were ordered to pay around £500,000 plus costs. Rubberstein subsequently issued 2 emails addressed to the adjudicator and copied to Trant. The first one stated that they did not accept the adjudicator's jurisdiction, nor recognise the ruling, and the second asserted that the adjudicator was not entitled to make any rulings. Rubberstein then served a notice of its intention to refer the dispute concerning its liability for defects to arbitration, relying on its email, the second one in April 2021. As their notice of dissatisfaction, the parties agreed the arbitrator should first determine whether Rubberstein had served a valid notice of dissatisfaction to prevent the adjudicator's decision from becoming binding, and granted the arbitrator jurisdiction to decide the dispute. The arbitrator said that was not a valid notice of dissatisfaction, and he did not therefore have jurisdiction. Then Rubberstein obviously sought to appeal that decision to the court, and in support of this position, they stated that the arbitrator had reached an incorrect decision. And one of the points that Rubberstein raised here was that the notice of dissatisfaction was valid under their interpretation of Transport for Greater Manchester, which we just mentioned. And it argued that it had said no, a specific form of words or level of detail is not required to constitute a valid notice. Now, in opposition, Trant's argument was that the arbitrator has correctly interpreted Transport for Greater Manchester. And it was not a valid notice in respect of the adjudicator's decision, but only a notice disputing the adjudicator's jurisdiction. And a notice of dissatisfaction should identify both the matter disputed and the intention to refer the matter to the next stage. And whilst the judge accepted the determination of the validity of the notice of dissatisfaction would substantially affect the parties' rights, the judge refused leave to appeal. The judge agreed with the defendant or Trant's interpretation of Transport for Greater Manchester that the notice needs to be clear and unambiguous, and also to identify both the matter disputed and the intention to refer the matter to arbitration. So that was really building a bit more, I think, on Transport for Greater Manchester and giving a little bit more context and clarity to it. A further factor actually that was relevant in that case was that the email was sent to the adjudicator and only copied to Trant, and the contract actually requires the notice to be sent to the other party. So again, this judgment really highlights the critical importance of ensuring that a purported notice of dissatisfaction is clear and unambiguous, and as a consequence of this, not being the case, is that the adjudicator's decision will become final and binding, and you may therefore by default have to pay a lot of money. The judgment emphasised again the court of really looking at or being increasingly reluctant to open up adjudicated decisions, and they are looking now to really protect that sort of pay now, argue later ethos that arguably is within the Construction Act. So moving on now to this next case, which is talking about dispute resolution procedures still. So we're done with notices of dissatisfaction, and we're just moving on to still within the disputes sphere. And in this case, Kojima had entered into a contract with the Children's Art Partnership to design and build actually the redevelopment of the Royal Alexandra Hospital for Sick Children in Brighton. It was a PFI project, and CAP had a project agreement with the NHS Trust. There was a dispute resolution procedure in the construction contract which required disputes to be referred to a liaison committee prior to instigating court proceedings. it was identical to the one in the project agreement, save that it referred back to the committee, which was, the committee was defined as the committee in clause 12 of the project agreement. Now, this appeared to indicate that Kojima was not entitled to have a representative on the liaison committee. So anyway, moving on. Defects arose, and about 1 week before the expiry of the limitation period, CAP issued proceedings in the Technology and Construction Court, but without referring to the liaison committee. CAP then applied for a stay so that they could have then time to go back and go through that contractual process and refer to the liaison committee. And Kojima applied to the court to strike out the claim on the basis that they had failed to comply with the DRP, or the dispute resolution procedure, before bringing their original claim. Yeah, so the TCC decided that compliance with the dispute resolution procedure was a condition precedent that had not been complied with. But in any event, the dispute resolution procedure was unenforceable for uncertainty and lack of clarity. The judge states that it had the dispute resolution procedure been enforceable, she would have stayed proceedings rather than striking out the claim, and that a stay was the appropriate or default remedy. This then went to the Court of Appeal, and Lord Justice Coulson held that the judge had correctly decided that the dispute resolution procedure was unenforceable for uncertainty, particularly since Kojima could not be bound by a committee, it would not be represented on. And also noted there were other uncertainties about how the referral process was to be commenced and conducted. And he also stated that whilst the court had to endeavour to enforce the agreement between the parties, it should not overstrain to do so as to arrive at an artificial result. The court should not isolate the provision requiring referral to the liaison committee and ignore the other parts of that process that were unclear. It was not appropriate for the court to be teasing out the contractual process one element that might be capable of being salvaged, even though other parts were plainly unenforceable. So basically saying you can't pick and choose. He did go on to say, though, that a stay is not an automatic or inevitable remedy when a party neglects the contractual dispute resolution procedure, and the appropriate remedy will always turn on the facts of the case. So this really is actually quite a reminder, because that's quite an interesting point there, that the need for clarity, firstly, in dispute resolution procedures, and in the context of NEC, I mean, parties should obviously be very careful if ever amending the W clauses or supplementing them with some sort of referral to senior representatives that is different to the ones that are included in NEC4. Particularly if we're looking at multi-tiered contracts and we're looking at dropping down some provisions or cross-referring, always make sure it works and sufficiently clear. And the provisions aren't just entirely repeated without thinking about how they might need to be changed. But another interesting point here is the fact that a stay was found not to always be the default remedy. So this means that if there's a dispute resolution procedure in the contract that hasn't been complied with, then it could, in certain circumstances, mean that a claim is struck out for the fact that that has not been complied with. So that's particularly warning to anyone bringing those kind of claims and nearing the end of the limitation period. They may not necessarily be protected. So this now is the last case, so I'll just go through this one quickly because I think Glenn wanted questions at the end. So the last case is actually the one about whether collateral warranties can be construction contracts. And we haven't had a case talking about this for quite some time. And in this particular case, Topham Holdings and Abbey Healthcare, they Simply Construct have been engaged actually under a JCT, I'm not sure if we're allowed to mention JCT, it was JCT Design and Build, not an NEC contract, probably where I went wrong. So they were engaged to build a care home that was completed in 2016, and Simply Construct contractor were required under that contract to provide the freeholder, Topham Holdings, and any tenant with a collateral warranty upon being provided with notice by the employer. In 2018, there was some fire safety defects, and Topham had engaged a third party to carry out remedial works. those works had also been contributed to by Abbey, who were a long-term tenant. But the collateral warranties had not been entered into. They were entered into in June 2020. Practical completion of the works, practical completion of the works was in February 2020. It was actually, I think, October 2020, after even the remedial works were done, that I think Abbey's collateral warranty was entered into. So it was entered into after all the works had been done. There were adjudication proceedings, and both parties were awarded the cost of the remediation works. Obviously, they simply resisted this on the basis that the adjudicator did not have jurisdiction, as the collateral warranty is not a construction contract. And then initially, the Top Technology Construction Court determined that the collateral warranty was not a construction contract. It was not an agreement for the carrying out of construction operations, as Topham and Abbey did not have a right to adjudicate, and they were both required to bring fresh proceedings. And the wording was compared to the warranty in the Popwood Leisure case, and placing importance on the fact that, unlike in that case, the works had been completed long ago, so therefore it couldn't be future works that the contractor was warranting. The Court of Appeal overturned this decision, emphasising that whether a particular contract is a construction contract was a matter or a question of fact, depending on the wording and context of the specific contract. And the wording here was future-facing and retrospective, so that usual wording you see collateral warranties that say, they warrant to carry out and complete the works. And consideration was found to be that it was a construction contract for the purposes of the Act, and therefore there's a statutory right to adjudicate. The fact that the warranty was executed after the works were complete was found to be of little relevance in deciding whether it was a construction contract, as the collateral warranty has a retrospective effect. But in any event, I think one of the things that I think Coulson was actually looking at in that case was the fact that if say, for example, Topham had entered into the collateral warranty before the works are completed, and then Abbey entered into one after the works are completed, and that those warranties had exactly the same wording on them, it would be a bit of a nonsense to say that Topham's was a construction contract and they had a right to adjudicate, whereas Abbey did not. So really, I think there was some other discussion of some of the other wording, the Parkwood type wording, which was about acknowledges and undertakes. And Coulson again said that doesn't really make any material difference, considering the difference to be splitting hairs. I think this, so we have more clarity now. This could be quite broad-ranging because a lot of beneficiaries could then have the right to adjudicate under collateral warranties. Or alternatively, clients and contractors might want to think about how they word those warranties, whether they don't have those future-facing obligations in there to try and prevent this from being a construction contract and more of a sort of, like the wording of a product warranty. But it's important to note that this is actually currently, it has a legal appeal to the Supreme Court, so I guess really watch this space on that one. So just a quick summary, really the key there is the clarities of the drafting, clear payment notices, clear and unambiguous notices of dissatisfaction, comply with your dispute resolution procedure if it's in the contract before you go to the courts, and be careful about whether or not you want your collateral warranties to be a construction contract with the right to adjudicate. And that's it.